Hello and welcome to this, the third of our seminars on the subject of GDPR and the impact upon retailers. If you've listened to the other two webinars in the process, you'll know that we are today looking at the subject specifically of how retailers should be working with third parties within their ecosystem of e-commerce operations, what we're going to refer to as data processors, in order to understand the important implications that GDPR now plays directly on those data processors and how retailers need to prepare themselves ahead of the deadline of the 25th of May. As previously, we are joined the seminar today by our friends from White and Black. So Nick and Phil will be taking you through the detail in terms of understanding the implications of data processors and how you should relate to them. I'm going to give you a very quick recap now, just for the sake of ensuring continuity from the previous seminars in terms of the content that we covered, so we can then dive down into the detail. So without further ado, perhaps as a quick reminder, GDPR, the General Data Protection Regulation that is being rolled out as of the 25th of May next year, is primarily there to protect consumers, citizens of the EU, in regard to the data that is captured about them, about their private information, to ensure that it is looked after, it is secure, and it is only used in a fair and lawful way. It's based upon what is known as rules-based regulation, meaning there is no hard and fast document or specification that we can give you to say how you should invoke GDPR compliance within your organization. You have to go through a risk-based assessment to understand what kind of data you're holding, the relevance of what is being held, to make sure that it is only being used for the purposes set, etc., and auditing your suppliers to make sure that they can honor your obligations. So all of that is required to be in place. In terms of complicating the matter, we also have touched upon the point that as well as GDPR, there is the activity around e-privacy regulation, so the things that dictate the use of cookies and direct marketing, which is evolving at a different timeline. So we will talk to that where appropriate throughout this presentation. But just to remind everyone, Brexit does not get in the way. This is going to happen. Everyone has to be prepared. The principles under which we have discussed preparedness have fallen into the categories of ensuring we understand what fair and lawful processing are. In our seminar 1, we took you through understanding those definitions. In seminar 2, we gave you some worked examples. And if you'd like to refresh your memories by going back to those seminars, it would certainly be worth doing so. And if you would like demonstrations of the tools that can be offered to help you shape your user experience and how you bring fair process notices more into the customer journey, we'd be happy to take that conversation offline from this webinar. In terms of lawful processing, just to remind everyone, it's our strong advice that from an e-commerce operations point of view, that you rely on performance of a contract and legitimate interest as far as you possibly can as the basis of doing your trade online, and that you only really rely on consent for your marketing activity, and if you do require special data such as information about religious beliefs, trade union membership, sexual orientation, etc. But the vast majority of retailers who don't require that data should be looking to rely on performance of a contract and legitimate interest, and therefore having clear and accurate fair process notices reflected on your website to enable you to process transactions without relying on any consent. And beyond that, in the last webinar, we also talked about the new rights that are applicable to data subjects or your consumers. I won't go through them all again here and now. Again, you can go through that in seminar 2. But just to say that these rights are new, and what is important is that you are able to enforce those rights on behalf of your consumers as at the 25th of May next year. It's not optional, it is mandatory, and where you will typically be relying on third parties to deliver your end-to-end service to your customers, where private data moves from you as the data controller into other data processors to deliver that operation, it is essential that rights such as the right to be forgotten, the right of access to data, that can be enforced through that supply chain. So it's a very critical element that is going to be increasingly important that you inspect with the people that you rely on to deliver your end-to-end service. So, as a lead into today's conversation, everyone that's listening to this call is likely to be a retailer. The retailer in this instance we are talking to as being the data controller, meaning that you are the organization that is ultimately responsible for the care and supervision of personal data that is captured upon citizens of the EU when they're trading. And just as a reminder for everyone, it does not matter what technology you rely on, where that technology, if it's hosted, is served from. It can come from any country around the world. If it is being used and accessed by EU citizens, then they are captured under GDPR and you have an obligation. As the controller, you're ultimately liable. But as we're now about to discuss in some detail, White and Black are going to take us through a review of how GDPR is putting new obligations on data processors so that there is some joint and several liability. With that in mind, I would now like to hand over to Nick Mathis. Nick's going to take you through a general introduction to this area, and then Phil will look at some of the detail around how to contract for that. So Nick, may I hand over to you?
Many thanks, Andy. So I'd now like to spend some time looking at just why it's so important to get your supplier dependencies right in preparing for GDPR. So on the next slide, as you'll see, we've highlighted some of the key changes under GDPR with respect to engaging with suppliers who are treated as data processors under the law. As the Information Commissioner, Elizabeth Denham, says on the slide, what's very different under the GDPR compared to the current law is that processors will have direct responsibilities and obligations under the GDPR which are outside the terms of the contract. And if they breach those terms, then they may be subject to administrative fines, sanctions, and potentially liable to pay compensation to data subjects. So if we start at the top of that wheel of 5 core changes there, for retailers, it's important to be aware that there will be stricter requirements for selecting your providers before entering into contracts with them. As we move round to the right, you'll see that there are many more detailed requirements for the terms that need to be included into your data processing agreements with those providers, which Phil Thompson will come on to look at in more detail later. As we move down, it's this core point that not only are the processors directly regulated under the law, they're liable to the data subjects. So in the retail context, this will be the customers of the retailers, and both the retailer and the supplier will be jointly and severally liable, potentially, for compensation claims. So moving on, it's important to be aware that for all retailers, just to what extent they are reliant on providers as data processors, both in the customer data-facing parts of their businesses, but also internally with respect to employee data. So taking those in turn, retailers will typically be engaging with data processors in respect of the different elements of the e-commerce platform and the fulfillment process, ranging from web hosting and payment solutions through to analytics and logistics and fulfillment. But internally, most employees within retailers will be relying on IT software and services with respect to processing employee data as well. And again, this is ranging from common IT cloud-based software packages such as Office 365 through to the outsourcing of payroll. As you'll see on the next slide, the core point here is that retailers are responsible for data processors. That's also the case under the current Data Protection Act, but the consequences of a breach by a data processor become much more significant for retailers under the GDPR, given the much higher fines. So as you'll see that we've highlighted the core obligation under the Article 28(1) of the GDPR, which is that retailers may only use third-party data processors where those processors can provide sufficient guarantees that all the processing undertaken by them will meet the requirements of the regulation. And as we've highlighted in the first of those 3 points on the slide, retailers are not only responsible for the first provider that they may engage in relation to data processing, they are also responsible for any other third-party providers which that first provider may engage. And this is very common, particularly when you're dealing with cloud-based services, and there is a potentially quite long and complex chain of different entities involved. The second point here is that retailers cannot outsource their regulatory liability. It is possible to apportion risk within the contract, but you will always remain primarily liable under the law to the regulator and to your customers if there is a breach caused by any processes that you engage. And thirdly, you need to have a written agreement, including mandatory provisions, and these are going to become far more detailed. So on the next slide, we've set out visually by way of a diagram to illustrate how, in practice, the different parts of the GDPR are likely to apply. So as you'll see on the left-hand side of the slide, there is personal data coming into your organization from customers and employees. And as we've dealt with in previous sessions in more detail, all of these data subjects have a series of enhanced, strengthened rights under the GDPR. As a retailer and data controller, you will have potentially joint and several liability to these data subjects. And so if you breach, or if you or your suppliers breach any of your obligations and it causes, for example, distress or financial loss to any of those individuals, then those individuals may choose to sue, either to bring a claim either against yourself or against the supplier or against both of you, depending on the circumstance in which that breach took place. As we look down to the bottom of the slide, we can see that enforcement action will look different under the GDPR because the ICO, as the regulator in the UK for data protection, may potentially be able to bring enforcement action against not only the retailer as controller, but also suppliers as data processors. However, because this is a new obligation under the GDPR to bring processes directly within the scope of regulation, we still don't know how that's going to work in practice, both for enforcement action and in terms of any litigation or even group litigation brought by individuals. And so as we summarised in the box as to what we're seeing in the market, this lack of clarity as to how enforcement and compensation claims may actually play out in practice. We're seeing this leading to potentially quite long negotiations between retailers and suppliers with respect to renegotiating existing agreements and entering into new agreements. We're also seeing resistance by providers to assume uncapped liability for any breaches of the GDPR which they may cause. And it's also very important to remember that both retailers and suppliers will need to have appropriate insurance cover in place to cover these different types of risks. As we'll see from the next slide, as we come back to this risk-based approach that we've looked at in more detail in the previous seminars, it's very important in preparing for GDPR that retailers focus time and their budget to those areas of data protection compliance within their businesses that present the highest risks to their customers and to their employees. And as we've seen from repeated assertive enforcement action by the ICO for security breaches involving processors, which we'll look at in terms of a few case studies on the next slides, that the use of processors is a high-risk area and should be treated as such in preparing for GDPR. So as I said, on the next slide, we've highlighted a couple of serious incidents which have previously arisen involving suppliers to draw out some of the key points in terms of how the ICO will actually enforce any breaches against the retailer for their use of third-party suppliers and how they actually weigh up the aggravating and mitigating factors in those cases. So to summarise, in the first case in NHS Surrey, the NHS Surrey Trust engaged a third-party supplier to destroy over 1,500 hard drives. The supplier was reputedly a certified and reputable supplier. However, the hard drives were not destroyed. They were actually sold on an online auction site and purchased by a member of the public who was able to access thousands of sensitive patient and medical data and HR data. They subsequently alerted the NHS Trust, who reported this breach to the ICO. When the ICO investigated the incident, they imposed a £200,000 fine, which currently represents 40% of the maximum £500,000 fine under the current Data Protection Act, although of course that would be far higher under the GDPR. The factors that they said were important, the mitigating factors to reduce the fine against the NHS, were factors such as the NHS voluntarily reported to the ICO, they were very cooperative and they took remedial action. However, the fact that the NHS Surrey Trust had not had a proper written compliant contract in place and that they'd not exercised enough oversight over the destruction of those hard drives led to the ICO imposing this fine. And it was important in this case to note that the ICO considered that the NHS Surrey Trust should have actually monitored the physical destruction of those devices in order to comply with its obligations. Clearly, in the online cloud context, it will be even more difficult for retailers to actually monitor the deletion or destruction of data. And so it will be important to check very thoroughly before engaging with any suppliers as to what steps they take and how it can be verified that any data destruction and other compliance with obligations under the GDPR will actually be complied with. The second case study with the British Pregnancy Advisory Services It's an organisation which operates an abortion helpline, and they had engaged 2 suppliers to develop a website appointment booking system. The first supplier was to develop the system, and the second supplier was to host it. However, the website inadvertently retained very sensitive callback details of nearly 10,000 helpline users. The website was hacked by an ethically motivated hacker who threatened to publish this information in the public domain, which could have caused severe distress and potential harm to those individuals. In the end, the hacker was unable to publish because they were caught by the police, but still the ICO imposed a fine of £160,000 in this instance, so 32% of the maximum under the current law, because the BPS has failed again to have a written compliant contract in place with either of those 2 suppliers. And importantly here, they had failed to provide a detailed specification for the first supplier to build the website with sufficient security to not only protect data, but to prevent data being inadvertently recorded in the first place. Again, factors in favour of the BPS to mitigate and reduce the level of that fine were that they were voluntarily reported and were very cooperative. But both of these case studies illustrate the importance of having a written contract in place and of doing thorough due diligence on your suppliers to find out what measures they're going to take to actually protect the data, and then to actually ensure that in practice the data is protected. Before I hand over to Phil Thompson to look at auditing the supply chain, on the next slide there is a very recent and relevant example of how the ICO has specifically targeted small to medium-sized online retailers for their use of third-party processors. Again, this related to a situation where an online retailer, Construction Materials Online, had a website developed by a third party, and the website had vulnerabilities in it which allowed a hacker to hack into the website and to access nearly 700 unencrypted cardholder details that led to fraud. And again, when the ICO looked at the incident, they took into account that the online retailer had voluntarily notified the ICO and cooperated with them and taken remedial measures. But the fact that the website developer could have created a secure website without this risk, if Construction Materials Online had instructed them properly, was one of the core factors in imposing this fine. So hopefully that helps provide, again, another example of why it's important to not only do due diligence and engage with suppliers who can demonstrate that they will ensure the protection of the data, but to ensure that actually in practice on an ongoing basis that any websites or other areas where data can be potentially accessed by hackers are kept safe. So with that in mind, I'll hand over to Phil Thompson to look at the important topic of auditing the supply chain.
Thank you, Nick. I'd just like to take a couple of moments to look at what retailers should be doing in advance of the GDPR coming into effect in May 2018. If we look at the first slide, as you'll see in some recent guidance from the Information Commission's Office, they've made it clear that the obligations under the GDPR will not only apply to future contracts, but also to existing contracts that retailers have in place. As you'll all know, it's quite difficult to negotiate with your suppliers mid-term where there is no other intervening event that would ordinarily lead to such renegotiation. And so we need to approach this quite carefully. And the first instance, we would advise that retailers should review their existing contracts to determine the extent that they may need to be amended to comply with the GDPR, and then to contact their suppliers to get a view on what the supplier is doing to bring itself in line with the GDPR, because they are directly regulated, as Nick mentioned earlier, and we'll go on to look at some of those obligations later on in the presentation. As part of the review, it's important to consider renewal dates or other timing triggers which could give some more leverage to the retailers to plan for change if the supplier doesn't give sufficient comfort around GDPR compliance. And in addition, we'd also advise sending an information questionnaire to obtain transparency on the supplier's chain, subcontractors and the like, because as we'll come on to see in a couple of slides later, that has more of a focus under the GDPR. In terms of future contracts, it's important to train staff throughout the organisation who are responsible for selecting new providers of what the retailer's position is on GDPR and what we will require suppliers to adhere to in terms of future contracts, and build GDPR compliance into all new contracts with suppliers from now on. And indeed, we're advising clients to include GDPR questions in their RFP process for future contracts. So moving on to the next slide, we thought it'd be useful to look at some of the technical and organizational questions that retailers are now asking suppliers. Because of the accountability principle under the GDPR, a lot of retailers are focusing on whether there are third parties that could provide some comfort around the supplier's compliance with its information security obligations. And so we're increasingly seeing retailers asking suppliers around their accreditation under ISO 27001 and such other relevant accreditations. In addition, we have to bear in mind the enhanced data subject rights under the GDPR and the reliance that retailers will have on suppliers for enabling the retailer to comply with such data subject rights. And we're increasingly seeing retailers ask more technical questions of their suppliers around issues such as storage of data, going down to such detail as primary and failover, where the support and maintenance teams are based, and increasingly asking more detailed questions of suppliers around the technical capability of their systems to respond to individuals' rights, such as the right to be forgotten, the right to have their data ported to a new supplier, etc. It's also important, as you will have seen from Nick's case studies, to ensure that we audit the supplier's organizational measures to comply with its GDPR obligations. So we're increasingly seeing retailers ask about incident reporting systems in the case of a data breach or other breach of GDPR obligations. Wanted to have a look at the record keeping procedures that the supplier has in place to ensure that there's a proper compliance paper trail, and also seeking enhanced audit and access rights for the supplier's systems and records. Then moving on to the next slide, there are certain key legal questions that we're seeing retailers ask of their suppliers. At a very basic level, we're obviously asking suppliers to confirm that they are willing to enter into a GDPR compliant data processing agreement and to provide the necessary assistance to enable retailers to comply with their GDPR obligations. Without those two commitments, retailers will simply not be able to engage with suppliers. We're then seeing a bit more of a focus on the supplier's supply chain, the subcontractors that they may use, and the transfer of data within the supplier's organization for things like follow the sun support, because we are required to provide much more detailed information in these areas to data subjects in the fair processing notice that we have in place. And indeed, in relation to transfers, they attract some of the more higher fines. At a more commercial level, we're seeing greater focus on issues around termination rights and data protection compliance being called out as a material obligation under a contract. But as many of you will know, with these business critical IT systems, having a right to terminate a contract on 30 days notice isn't much comfort. And so we're seeing at least as much focus on what assistance is being provided by suppliers at the end of the contract, so-called transitional assistance. And because of the direct liability that suppliers might have under the GDPR, we're also seeing an increased focus on the liability piece around GDPR clauses. And it's becoming fairly common practice for GDPR provisions in the contracts to have a separate liability cap to the standard contract liability cap because of the nature of the fines that may be issued under the GDPR. Though the counter to that is that we're seeing increased resistance from suppliers to accepting unlimited liability for data protection related breaches. Moving on to the next slide, to look at some of the more specific aspects that the GDPR requires retailers to put in their contracts with processors. This can really be split into two parts. The first deals with the processing details, i.e. what the processor will be doing on behalf of the retailer. And we're now required to set out in the contract the subject matter of the processing and how long that processing will take place. Why is the processing taking place? and what type of personal data and what data subjects does it relate to, in addition to specifically setting out some rights and obligations of the retailer itself. And then, as we've mentioned earlier, there are now certain specific obligations placed on a processor under the GDPR which are required to be included in the processor agreement. These include only processing on the retailer's documented instructions, ensuring that staff processing personal data keep such data confidential, complying with the technical and organizational security measures in the GDPR, and only using subcontractors with the retailer's written consent, and ensuring that the contract with such sub-processor mirrors the contract between the processor and the retailer. In addition, we're seeing contracts setting out that the processor must assist the retailer with responding to data subject access and their rights, complying with the retailer's obligations regarding security breach notification, impact assessments where these are required, and obviously consulting with authorities where needed to do so. A key point is obviously ensuring that data is deleted or returned at the end of the contract, and retailers are asking processors to make the accountability information, i.e. the paper trail, available to the retailer, including allowing and facilitating auditors by the retailer or their auditors. In addition, the processor is required to tell the retailer if anything that the retailer is asking the processor to do infringes GDPR or other data protection law. Moving on to the next slide, to understand how processors are directly regulated under the GDPR, I would like to first look at some of the operational aspects of the processor obligations. As we mentioned in the earlier slide, one of the operational aspects is to only act on the written instructions of the data controller, and the key part of this is if the processor does not only act on the written instructions of the controller, this in itself could result in that processor becoming a controller under the GDPR and finding themselves subject to all of the controller obligations, which go much further than the processor obligations. They've also got to ensure the security of processing, as we mentioned earlier, and to ensure that international transfers, i.e. transfers of personal data, which includes storage and accessing of personal data outside of the European Economic Area, are compliant with the requirements of the GDPR. Moving on to look at some of the other areas where processors may be directly regulated. The first aspect of this in the next slide is the incident management, which we discussed, such as notifying personal data breaches to the controller and cooperating with the Information Commission's Office, who's the data protection authority in the UK, or other competent regulators where you're dealing with other jurisdictions within the European Economic Area. And from an administrative and organisational perspective, processors are required to keep records of their processing activities, particularly if they have more than 250 employees. In certain circumstances, depending on the amount of data which they process or any monitoring, they may be required to employ a data protection officer. And if they are based outside of the European Economic Area, they may be required to appoint a representative within the EU. There's been many talk and other commentary on the sanctions which may be imposed under the GDPR, but perhaps one of the least well-known areas which could affect processors is this right under Article 58 to issue a ban on processing in certain circumstances, which could seriously undermine a processor's method of doing business, and hopefully should mean that processors want to assist retailers in getting this right. So moving on to the next slide, looking at some of the areas where the retailer may wish to back-to-back its obligations and liabilities under the processing agreement. We obviously would want the retailer to be indemnified in respect of losses which arise out of the processor's breach of the processing agreement or indeed applicable law. Similarly, one of the data subject access rights is to require the retailer to suspend or cease the processing of personal data. And it's obviously critical where we're reliant on processors to undertake processing on our behalf, that we have the right to require such processors to suspend or cease data processing. We're often going to be required for the processors to provide data to us in a format that is commonly used to enable us to meet our obligation to allow the data subjects to access their right to data portability, and we will require the processors to notify us where they suffer a data breach and to provide that notification with sufficient detail to enable us to inform data subjects and make an assessment as to whether there is any other action to be taken. We've mentioned record keeping as it being an important point to enable the retailer to comply with its obligations, to be able to demonstrate compliance with the GDPR and to ensure that it can properly audit its processes' obligations under the contract. And similarly, retailers would still want to have direct control over any correspondence with the data subject to whom the information relates, and so we want the processor to notify the retailer where a data subject has contacted the data processor directly, and also to be able to correct the records of the data subjects where this is necessary. We've mentioned earlier that there's going to be a requirement to oblige processors not to transfer personal data unless the retailer has consented to do so, and that the retailer will require processors to assist the retailer in carrying out data impact assessments where these may be required. So passing back to Nick, we've touched on a couple of points regarding data transfers, and this is obviously a critical aspect of any supply chain. So Nick's going to focus a little bit on this area.
Thank you, Phil. So as we move on to the first slide in this section, which sets out visually an example of how data transfers may occur when a retailer is engaging with suppliers offering cloud-based services. As you'll see on the right-hand part of the slide, the personal data will be coming into the retailer, collected by the retailer from customers and employees, and often it will be transferred outside of the European Economic Area, that's the 28 EU member states, together with Norway, Iceland and Liechtenstein, to countries such as the United States or Japan, for example, where there are data centers that store the data in order to provide these services. And then it's very common for those suppliers to make further onward transfers to other suppliers which they rely on in the supply chain for that particular service. So as we turn to the next slide, we've listed out some of the areas where transfers are particularly common for cloud-hosted services that are used by retailers, and these range from common software packages such as Microsoft Office 365 or Lotus Notes, through to hosting, storage and platforms such as AWS and Microsoft Azure, down to CRM solutions, e-commerce platforms and payment and fraud prevention services. These are just some of the examples of where transfers are common, and there are many others besides. As we'll see on the next slide, the basic principle under the GDPR is the same as under the current Data Protection Act, which is a transfer of personal data outside the European Economic Area by a retailer who's based in the European Economic Area will be restricted unless certain conditions are satisfied. Firstly, if the transfer is sent to a country which offers adequate protection, so one of the 11 countries on the whitelist, or for example to a US company that's registered with Privacy Shield, then the transfer will be compliant, subject to agreeing a GDPR processing agreement which satisfies the requirements that Phil's already discussed. Secondly, if the transfer will not be to one of those whitelist countries or to Privacy Shield, then appropriate safeguards should be considered. And it's very common for retailers to enter into so-called EU-approved standard contractual clauses, sometimes known as model clauses, which are data transfer agreement which has been approved by the European Commission as satisfying the requirements for sending data outside of the European Economic Area. If that is not possible, then you may consider relying on a derogation. The most common one to date has been for retailers to rely on obtaining their customers' consent via a privacy notice. However, this is a measure of last resort that should not be relied on if it's possible, for example, to put in place a model clause contract. And in any event, it cannot be relied on in relation to transfers of employee data, because employees are deemed not to be capable of consenting. So on the final slide, we'll see now in terms of the future for international transfers, the GDPR is seeking to assist companies that are operating in an international manner or using international services by providing additional options for transferring personal data outside of the European Economic Area. Firstly, as we'll see at the top right-hand box in the square there, that it will be easier to obtain binding corporate rules. They're available under the current regime, but are typically very time and cost intensive. And so the GDPR aims to make it easier for multinational companies, such as multinational retailer groups, to obtain binding corporate rules to allow them to transfer data within that corporate group. However, that will not necessarily allow you to transfer it to suppliers. So however, suppliers may also be able to obtain binding corporate rules. We hope to see this being adopted by suppliers going forward as one of the ways of making it easier for retailers to comply with the transfer obligation. Similarly, the GDPR allows for companies to, both controllers and processors, to obtain certification by an approved external certified body. And if you do obtain certification, or if you subscribe to an approved code of conduct, then this will also provide an option for transferring data outside of the economic area, provided that other safeguards are also put into place. In relation to consent, it will need to be now need to be explicit, which presents a very high threshold to demonstrate that the consent has been explicitly obtained. And in any event, this is a derogation, and we would not recommend that retailers seek to rely on consent. They should be putting into place long-term data transfer mechanisms, such as model clauses. And in terms of the enforcement risk around data transfers, whilst to date we have not seen this as an area where the ICO has actively been able to enforce the law, we are seeing a new trend in the continent. For example, in Germany, where the authorities randomly audited 500 multinational companies and took action against 3 of those companies, so Unilever, a Pepsi Group subsidiary, and Adobe, because they had failed to put into place transfer mechanisms to ensure that the transfers were lawful following the invalidation of safe harbour. And we may see a similar approach adopted by the ICO in the future under the GDPR. So that brings us to the end of the seminar. I'm going to hand you back to Andy to wrap up.
Thanks very much, Nick. And so obviously in this session, we've gone into quite a significant degree of detail compared to the previous 2 seminars, because it's essential that we understand what is fundamentally perhaps the biggest change that retailers are going to have to come to grips with in the near term, which is understanding which organizations you're depending on that are data processors, understanding whether your contracts are due for renewal before the 25th of May next year, so that you can ensure appropriate compliance to GDPR is enshrined within those agreements, and therefore able to be offered back to back from your suppliers to yourself out to your consumers, the citizens of the European Union. And obviously, if you have contracts that are in place that are going to go beyond that date, then clearly, based upon the information that you've heard today, it is going to be essential that those contracts are renegotiated. And it's equally essential that all of the suppliers that you rely on understand their obligations under GDPR, which is an activity that we're also trying to help support in the marketplace to ensure that you're legitimately able to work with those organizations beyond the data compliance next year. So just as a recap on the whole subject that we've been taking you through, we've given you an oversight into what GDPR is in the large framework. We've given you hopefully some confidence and clarity in terms of relevance to your organization. At the end of the day, as we say, this is not something that we can prescribe. It is principles based. Nothing is going to take place of you carrying out within your organization an assessment of risk, an assessment of what data you are capturing, an assessment of which third parties you are using, and ensuring that you are securing data, only retaining data that you absolutely require, and only using it for the legitimate purposes that the consumers allowed you to use it for in the first place. Clearly, there's a lot of detail behind all of this, and what we hope we've achieved through these 3 seminars is that at least enable you to go from a very big picture down to some relevance and certainty about the calls to action that you need to put in place within your organization. Having someone in role as a form of a DPO we see as absolutely important. Having executive boardrooms and commitment to ensure that you are GDPR compliant, we see as also absolutely essential. If we, Tryzens, or for Phil and Nick through White and Black, can be of any assistance, our contact details are on the final slide. We'd like to thank you for your time and attention. Certainly like to thank Nick and Phil for the great effort and insight that they've given us today. And with that, we will close the webinar and we will hear from you as and when. Thank you very much.